The Mad Hatter here with part 23 of the My Docket series on Corazon real estate. This is the last day of my punishment. I have caught up, and that's all 6 videos in a row for you guys. And I can recall this being about the reply to opposition on the requirement of Corazon real estate to pay those fees, and I think I also lumped in a court order. Usually I would do a separate video for the court's order, but it was a really cheesy order, and so it just doesn't deserve its own video. I'm just going to lump it into this video. My mindset would have been probably also annoyed. I was probably thinking, why is this attorney trying to not pay costs? It's ripping off the government. They lost the appeal. It makes sense that the government should get its money. I mean, the whole thing to me was beyond silly, but at the same time, sometimes attorneys will do this. Sometimes they will pay $250 in attorney fees to avoid paying $250 in costs. I mean, in the end, I think she was right, because I mentioned that in my last video. Having taken a look at those two, that one case and that one statute, it does seem to me like she was right. But it's kind of a Pyrrhic victory, because they had to pay the they had to pay the same amount anyway. In my opinion, he may have even had to pay more. If he's lucky, they were really nice and they just waived it for him. It's possible. Sometimes attorneys do that. In any event, I think really this is going to be one of those videos, just like most of the others in the series, that we are going to have to just go straight into what I have filed. Here we have the reply to opposition to motion to require Corazon real estate to pay the costs of filing fees to the court. I am going through standard introductory paragraph indicating that I am appearing in proper person, which means I don't have an attorney, and that I'm filing a reply to the defendant's opposition to motion. Motion opposition should not be combined. Right away. First thing that I mentioned. WDCR Rule 10 Sub 9. Any motion, opposition, reply, etc. must be filed as a separate document unless it is pleaded in the alternative. It unnecessarily complicates the responsive process. Should this be an opposition, a reply to opposition, or both? The plaintiff requests that the court disregard the motion to strike and construe defendant's pleading. It's not a pleading. It's another paper. And construe the defendant's other paper as an opposition to motion. My reply to that opposition to motion now follows. The remitter. The defendant cites, whoa, this thing needs some serious glue. The defendant appropriately cites Dickerson v. State, our superior court, lowercase s, lowercase c, because in some states there actually is a superior court. What I'm trying to say here is the next level up. Supreme Court, in discussing the effect and purpose of a remitter, refers to Buffington versus State, which elaborates that jurisdiction in an appeal is vested solely in the Supreme Court until the remitter issues. Under the relevant statutes, the Supreme Court has control and supervision of an appealed matter from the filing of the notice of appeal until the issuance of the certificate of judgment. The certificate of judgment and various other documents constitute the remitter. Under these principles, it is obvious that the court cannot make findings, considerations, conclusions, or enter any orders. Nowhere, however, is it stated or even implied that parties cannot file notices, motions, pleadings, or papers in the instant case. It was required. A remitter is not a judgment per se. It is the certification of a judgment. The time for requesting costs told from the date of our superior court's order entered, the order reversing, told from the date that the Supreme Court entered the order reversing and remanding. Had the plaintiff not filed a motion for costs within 5 days of that order, 18.110 sub 1 would have precluded any costs whatsoever. This is true. This is a little bit frustrating. And I talk about this in another case, Morrell v. Edwards, where in this case, the particular individual did not file his memorandum for costs on time, and he ended up not getting his costs. Concerning also is that if we follow the defendant's logic, the amended complaint is void ab initio because it was filed before the remitter issue. Yet the defendant failed. So she's being a hypocrite. So what I'm saying is that if we follow their own logic, then their own document is void ab initio. Oops, on their part. Quasi-estoppel applies where it would be unconscionable to allow a party to insert inconsistent positions. I think this is called judicial estoppel, but maybe I'm wrong. I've never heard of quasi-estoppel. And it's not good that I'm filing a U.S. Court of Appeals case. There's probably a Nevada case that discusses this that would be more on point, I'm guessing. So right away, this looks weird. I don't know why I did this. Legislative intent is controlling? Not really. Not really. Legislative intent only controls when there's ambiguous language in a statute. When there are two different statutes that contravene or contradict each other, stuff like that. I talk about this in the video Statutory Construction. Another problem is costs. Costs are in what they call derogation of the common law, which means that they're only allowed as expressly authorized by statute. And so I think I'm wrong here. Although pauper privileges are not expressly extended to the appellate process under 12.015, it does not necessarily render 12.015 sub 4 inapplicable to the instant case. Filing fees are a creature of statute, and the legislature, in enacting 12.015 sub 4, made it clear that when the fees are waived, they must eventually be paid by the losing party. I mean, maybe I still lean heavily in favor of the attorney being right, just because of the fact that costs are very strictly controlled by statute, and you can't really fill in blanks and wander off into other areas like I'm doing here. If it is true that the Supreme Court authorizes forum pauper status using its inherent powers and not 12.015, which is what I suspect, which is what the attorney asserted, if that is true, then most likely what I'm saying here is wrong. Yeah, see, we read statutes within a statutory scheme harmoniously with one another to avoid an unreasonable or absurd result. But this only applies when they look beyond the plain language of the statute. So if the statute is ambiguous or silent on the issue, really, I do believe that we are out of the boundaries of that statute, as that attorney has asserted. Conclusion, the state has impliedly entrusted collection of the filing fee to the district court. It's true, it just doesn't seem to apply when an appeal is the thing that has been waived for the filing fee. Rule 5, certificate of service indicating this document was personally served to Katherine Parks. Order striking pleadings. The judge, District Court Judge Scott Freeman, has reviewed the instructions from the Supreme Court of Nevada. He is going to comply with their order, and he is going to strike everything that Charles Chinichi filed in this case. Certificate of service indicating, wait a minute, hold on a second. What does he do about the order? Yeah, he's also striking his own order. So his own order granting the motion to dismiss, he's also, he's tossing it. Certificate of service indicating this document was mailed to me. And it looks like he's indicating Katherine Parks was served electronically. We got a disclosure here. An NRCP 7.1 disclosure. What is this? Okay, this rule seems to mirror the Supreme Court's 16.1 rule. There's another rule, Rules of Appellate Procedure, NRAP 16.1, that says the same exact thing. And it looks like for the lower court, they have to do the same thing. They have to disclose if there's any parent corporations. We got what is this? NRS 239B.030 indicating this document is not contain a social security number. We got a certificate of service under Rule 5B indicating this document was mailed to me. Order granting motion to require the defendant to pay the costs of filing fees to the court. This is what I was talking about. This is a cheesy order because it looks like I won. Look, he's granting my motion. I won, right? No, not exactly. Here's what he says. The court's in receipt of my motion to require costs be paid. He's also reviewed the opposition to my motion and the reply. I'm moving. Oh, okay, so he is aware. He knows that I'm asking the court to order Corazon Real Estate to reimburse $250 in costs that the plaintiff submits he was required to pay. Nope, that's what he got wrong. No, I didn't have to pay this. I would have had to pay it if I didn't get the fee waiver. Supreme Court issued an order awarding costs in the amount of $9. Therefore, he's awarding me $9. Yeah, he's not. It doesn't matter. He screwed up, but he ended up being right, I think, because of the other reasons. I don't think that the law supported the position that I took. So it doesn't look good. But in any event, even though what he's saying is wrong, he reached the right result because I do think that attorney is correct that 12.015 doesn't apply. So it's fine. It's fine. Certificate of service indicating this document was mailed to both, well, just to me, and then that the attorney was served electronically. Going into the aftermath, I filed, it looks like just one document. And it was a free filing, so I incurred $0 in costs. It looks like Corazon Real Estate filed also one document, but was a free filing, so they incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. And the document that they would have filed looked extremely basic, and the orders entered by the court were probably very much anticipated. In my reply to opposition, they don't have to do anything afterwards, so why would they care? 30 minutes, a little bit of a stretch, I think. I'm going to go ahead and say 15 minutes in attorney fees for Corazon Real Estate at the rate of $250 an hour. That's going to come to $62.50 in attorney fees for Corazon Real Estate. As in the previous videos, if you have any questions, feel free to post them down in the comments below. And the Mad Hatter will not be seeing you guys next time. I will be back as myself. Again, guys, thanks for these having some patience with me on letting me catch up on these my docket videos. I was 6 videos behind. I was 3 weeks behind, and hopefully I'll be able to stay above water going forward.